Hey friends, how are you? Welcome back to now Chapter 3 in the Massachusetts, which corresponds with Unit 4 and its interests in real estate. I know that last unit was a lot of definitions, and that's why I read them to you a couple of times and just reviewed them with you a couple of times. Now we're going to talk about the Massachusetts portion and see how it affects the interest in real estate, okay? Before we get going, let's just talk about how to maximize this chapter. So I want you to have your red book open to the chapter, and I want you to have your recorder on. So I think it's iPhone is voice memo and voice recorder for Android, and have them ready to record with a proper title prepared. Okay, so title it first, so that way when you are in your car driving and you're studying on this, you're going to be able to find it. Okay, follow the timed module, completing each task, including the quizzes. Okay, so the thing is on Massachusetts is that, it's not as much information to go through. So you're going to want to make sure you do the quizzes so that you have a way to check yourself, okay? And then again, the quizzes that we give you are not graded. You must complete them to move forward, and we will have questions there to ask you if you have any questions for us or what your observations are, or whatever we can do to help make these better for next time we roll these babies out. Okay, you can pause or rewind. Okay, you cannot like zip forward though. Okay, and you're going to record your progress as you go. Okay, recording all along so that when you're listening, it's comprehensive and it makes sense to you. And you're going to use that audio later for review. Again, I will tell you, the people who have had the best success in the class are absolutely the people who have recorded themselves. And you're going to use the live chat and questions below to get response from your team, which is me, Don Devlin, and Marie Greeny. Okay, so let's see what we got. We've got the estates and land. Okay, so we talked about the estates before, and I kind of glossed over the dower and curtsy part of that. And so now I just want to cover that with you. Okay, so estates and land is when a valid deed is delivered. The law presumes that the fee simple estate has been conveyed with the delivery of deed unless the deed otherwise specifically states it. So I think I said in the last slide presentation that, generally speaking, it is the fee simple estate. Okay, so what are some legal life estates? And dower and curtsy. So the purpose in underlying dower and curtsy is to protect the one spouse against disinheritance by the other spouse. At common law, dower was the right of a widow to an interest for life in 1/3 of all real estate owned by her husband during their marriage. And then curtsy was the right of the widower to an interest for life in all, for example, not 1/3 of the real estate owned by his wife during their marriage. Sounds like a fair law, doesn't it? The Massachusetts legislature has abolished the distinction between dower and curtsy. So, for example, what that means is now all rights are called dower, and has abolished the rights of dower except as to those lands owned at the time of death. Therefore, it is no longer necessary to obtain a release of dower or curtsy rights in the deed. Okay, so dower rights are really exercised. People who are dissatisfied with the treatment under their deceased spouse's wills generally choose to exercise their waiver rights under the Massachusetts law of descent and take the minimum statutory share of the estate. And this will be in Chapter 8, okay? So further, because most married couples hold their property as tenants by entirety or joint tenants, succession is not usually an issue, okay? So in the old days, only the male was on the deed a lot of times, okay? And then only if an individual dies insolvent may dower rights arise, and the surviving spouse's rights come before the claims and predictions. Okay, and what is our homestead rights? Now effective March 16th, 2011, a homeowner who does not declare a homestead exemption with the Registry of Deeds now has an automatic homestead protection of $125,000. I might double check that number, okay? A filed declaration of homestead entities are entitles homeowners and their surviving spouses and minor children to a life estate in the land and buildings occupied as their principal residence as a protection against attachment. levy on execution, or sale to satisfy debts to the extent of $500,000 per residence per family. Okay, so on the test, it will say, what is a homestead? Okay, and a homestead is a life estate. Okay, that is the simplest answer for that. Okay, we don't often use the homestead terminology in that way when we're talking about what a homestead does. Okay, and in real estate, when you're at closings, you'll hear them talk about the homestead in a different kind of definition, although it's just kind of like an applicable way of using this. Okay, so $500,000 per individual, regardless of whether such declaration is filed individually or jointly with another. If two owners qualify for the elderly or disabled homestead protection, the aggregate protection on the home must be $1 million. Okay, over the years, these allowances have increased. If a homeowner has already filed a homestead under the former allowance, the homeowner gets the increased protection without needing to file a new declaration. Okay, effective March 16th, 2011, a holder of beneficial interest in trust is considered an owner, eligible for the estate of homestead. If a home is owned in trust, only the trustee needs to execute a declaration of homestead on behalf of the trust's beneficiaries. The purpose of homestead is to protect an individual's equity in their home. A declaration of homestead exempts certain property, for example, land, buildings, and manufactured homes, from the laws of conveyance, descent, devise, attachment, and levy. Okay? So that's the part that's just a little bit different from the general. So I just kind of want to go over with you what the differences are from the general. Okay, so we have our easements, and we have easement by deed, easement by prescription, and easement by necessity. Okay. And following the three-way easements are commonly created in Massachusetts are by deed, by prescription, and by necessity, implied easements. Okay, so an easement by deed. An easement by deed can be created by deed when a grantor, number one, conveys a limited easement right to her property, or number two, conveys all her rights in a specific property but retains or reserves an easement. The grantor can use either a quitclaim or a warranty deed to create an easement. And again, this will be in Chapter 8. A quitclaim deed may be used to convey an easement when the grantor is conveying no other interest in Massachusetts. The quitclaim deed has special warranty deed status because of the title search process. An easement may be granted for a specific limited period of time to a specific individual or to a grantee or his heirs and assignees forever. Okay, so this is where you can save some rights in there. You can be specific on that. As I said, it's kind of interesting if you go and you read different deeds and find all sorts of different easements in there. All right, easement by prescription. An easement by prescription is the equivalent of adverse possession. In Massachusetts, the following 5 factors must be established in order to establish an easement by prescription. Okay, so again, when we did the general portion, I kind of gave you vague kind of ideas, okay, or vague requirements. So here's Massachusetts. The use or possession must endure for 20 years. The use must be continuous and uninterrupted. So I'll give you an example. There used to be the shortcut that many people would take to the beach. And the people who owned that land would let everybody go through the shortcut, except once a year they'd put a cone out so that people could not pass through. And the reason they did that was they did not want to have the easement by prescription. They wanted it to be interrupted for that one day. Okay, the use occurs without the owner's permission. The owner knew or should have known of the use but took no action to prevent it. A benefited parcel of land, usually abutting or adjacent, must exist. Okay, so I'm going to give you an example. The final factor is intended to prevent the public from obtaining an easement. The 20-year period may include previous uses of an easement, which is called tacking. Okay, so you tack on the years. So I'll give you an example. There was over by Fort Phoenix in Fairhaven, there was a pathway that all of the people on a certain road used to use to go to the beach, and they actually even had like a rope walk up there to get them there. and someone came and wanted to develop that land and put houses there. And the people who lived in those homes, they got together and they fought it by easement by prescription because they said that they met all the criteria. They had used it for 20 years. They openly and notoriously used it without interruption. The owner should have known and took no action to prevent it. And the benefit parcel of land, usually abutting adjacent, must exist. In this case, there was. Okay. So, anyways, this ended up being a kudo or a win for the people who lived in those homes because they did in fact say that they had easement by necessity. Okay, an easement by necessity is created when a seller conveys a parcel of land to the buyer. Okay, I'm sorry, easement by prescription. Let's go into easement by necessity. An easement by necessity is created when a seller conveys a parcel of land and the buyer has no way to reach the property except by crossing the seller's land or that of a neighboring owner. In determining whether or not an easement by necessity exists, courts will consider the intent of the parties at the time of the conveyance. In particular, the courts will consider the specific geographic condition of the property. For example, they will call it the lay of the land. The buyer's and seller's actual knowledge of the limited access and references or the absence of references to an easement or right to access made in the conveying documents, the deeds, right? The easement by necessity is not automatic as it is the 20-year prescriptive easement, okay? If a court determines that the parties did not intend an easement, none will be imposed. Nor will an easement be imposed if the grantee, by spending a reasonable amount of time and money, would be able to create another means of access to and from the property. Massachusetts courts consider each case on its own merits, and there are no hard rules. So back to that cranberry bog I told you about. There were two ways in. The person who was buying the property wanted to go in this way. So they went to do an easement by necessity and then use the easement by prescription to reinforce it, okay? So what is a license? A license is the smallest right a person can have in real estate. It's a permission or a privilege. It arises out of a contract, not from a grant of ownership. A parking place, a hotel room, and a movie seat are examples of licenses. If a person rents a parking space for a few hours, she has contracted for a certain amount of time the right of that land. She has the right to park her car there, for example, and the right to enter the property to recover her car. However, when the license is gone, then it is gone. And where the license is gratuitous, without payment or the underlying contract elements, the license may be canceled without notice and no legal recourse for the licensee. Okay, so again, if someone parks somewhere without permission and they did not get a license granted to them, that can be revoked. Okay, so a little bit different than the general. I hope that it made some sense for you. All right, I'm going to talk about riparian rights. Again, I said think in the general part not too long ago that when I try to remember riparian, I remember R is for river and R is for riparian. So that's my clue to what the riparian is. Again, in the littoral rights would be lake and littoral. Okay, so let's talk about riparian. The owners of property that include or lie alongside bodies of water face particularly ownership issues called riparian rights. In Massachusetts, there are 3 types of common riparian rights that have situations arise from them, and that is streams, surface waters, and tidal waters. The word riparian refers to the right of an owner along a river or watercourse, but when the rights are adjacent to a lake or the ocean, they may be called littoral rights. The terms riparian rights and riparian owner are often used in conjunction with all water-related issues. For study purposes, just remember that riparian refers to rivers and the following bodies of water, and littoral refers to lakes. Okay? So streams. If the stream is navigable, that is, if a boat can float down it, then the public owns both the water and the land under the water. The Commonwealth is responsible for the care and supervision of the stream. The owner of the land next to the stream, or through which the stream runs, owns the land up to the bank of the stream. An owner of land abutting a navigable waterway owns the right to use the water as it passes, but cannot obstruct it or prevent it from flowing its natural course or from being used in navigation. If a stream is not navigable, ownership may be held in one of two ways. First, if the stream separates the two properties, the adjacent landowners own the water in the land under the water to the center of the stream. Second, if the stream runs through a single property, then the riparian owner owns the water all the way across and all the land on both sides and underneath. So ponds and lakes. Surface waters, such as ponds, swamps, and lakes, are controlled by the state and are regulated according to anti-pollution statutes. Adjacent property owners own the land up to the shore and do not have unlimited rights to fill in a wetland or a lakeshore. Use of the water must be approved under the state environment laws. Okay? And tidal waters. An owner whose property abuts tidal waters, for example, oceanfront property, owns the land to the mean water line, or 100 rods below mean high water, whichever is less. The land between low water and high water is reserved for the use of public by state law and is required by the state. Okay, so beyond this chapter, I want you to read your key point review in the chapter, and I want you to read the quizzes and the answers. Are you right or wrong, and why? And I want you to take the quiz, recording your thoughts as you did. And I want you to send us your recording for us to use as your accountability. Again, these don't count towards your hours, but they help us kind of build your case for your preparedness for that test, okay? And then you're going to email us, or you're going to use our live chat in order to talk with your group, okay? Or you can text us with any questions. And again, some of the things that are a little idiosyncratic about Massachusetts we kind of uncovered here, and I hope that it was helpful for you. Okay, so anyway, this is your team of Kate Lanigan-McGregor, that's me, Don Devlin, who is your live instructor and also will be on these with me, these live videos, and Marie, who's our Dean of Students, who is your go-to person for most of the questions that you have and the logistics on things. So this is Kate Lanigan-McGregor. Be bold, be awesome, be you.